Do. So good afternoon and welcome to this webinar on the Mark Glenn case. We will be starting shortly. We just wanted to give everybody time to get here. Could I please ask that everybody turns off their cameras and microphones? Is that all right? There will be an opportunity for questions at the end. So we'll obviously ask everyone to turn their microphones back on then. I think we're just going to give it one more minute as we still seem to have people arriving. And just to let you know, this is being recorded. So if you want to ask a question and yes, if you want to ask a question and you don't want to be heard, maybe ask it in the chat. That's all I would say. So I think it is now. Is it now? Yeah, it's now 5 past. So I think we should probably start. Welcome to you all. Thank you very much for joining us. I am here with Rebecca Sheldon. Rebecca, are you going to say hello?
Hi, everyone. I'm sorry that I'm not on camera. There's a family issue happening, so unfortunately I'm not in a place where I can go on camera, but I am here, and I'll be presenting with Harriet.
Thanks, Rebecca. So this is about the case of Mark Glenn and HMRC. And we've called it when zero rating is controversial. And the only reason I think we've said this is controversial is because this case has been picked up sort of in the press as being a case that states that a hair loss in women can be a disability. And it seems to have been picked up as being on a broader level than I think it really is. So
yeah, I mean, sorry, Harriet, just to chip in. I mean, it seems as though it's sort of taken on a feminist position where it looks as though it's applying far more broadly than it actually is to what is in reality quite a narrow statutory VAT provision. But yes.
Exactly. Yeah, so we are going to talk about, hopefully you can all see the slides. We're going to talk just a little bit about what the case was actually about, the facts, the arguments, how the court dealt with it, what's coming next, and then we'll take some questions. So I think, Rebecca, you're starting, aren't you? I will move slides for you.
Thank you, Harriet. So if we go, so the Kinsey system, so we have some photographs there, sort of showing what the Kinsey system is for. So essentially, I ran the case by myself in the FTT, and what this case is about a particular type of system which enables very, very serious hair loss in women to be covered up in a way that doesn't involve the use of sort of wigs being stuck to heads. So
and that's the picture on the right, I think, isn't it, with the very severe hair loss?
Precisely. Whereas the one on the left is sort of more of a thinning, and that's a hair extension treatment which is separate. So that's not part of the Kinsey system.
And it's never been claimed that should be zero rated. Is that correct, Rebecca?
Absolutely, yes. So it's only ever been claimed that the one on the right should be zero rated, not the one on the left. Okay, so so the parties in the case, obviously Mark Glenn Limited and HMRC. And as I've just explained, it's a company which provided a hair loss replacement treatment known as the Kinsey system. It was created by a former hair extension technician and named after the person who still runs the company, Glenn, who obviously came to be our witness. So as I've said, the client group, it was used for women with severe, patchy or widespread hair loss or baldness. It wasn't suitable for women with ordinary thinning hair. Obviously, that's a sort of normal part of aging. And I'll come in to explain why it's not suitable for that in a second. But that was very specifically offered, as we've just said, as a separate hair extension product for thinning hair. And as Harriet has alluded to, it was treated as standard rated. And that was never in dispute. So if we move then to looking at the next slide in more detail about what the Kinsey system is about. So in the FTT, what we did was we got a video to demonstrate this system because it's relatively involved, and obviously writing it down doesn't have quite the same effect. But essentially, what would happen is the client would go into this company. I believe they have a place in Covent Garden, and if suitable, so there was significant or patchy hair loss, pricing structure was then explained. What would then happen is that they would colour match the hair swatch and send that to a wig maker to make the initial wig hairpiece. Now, crucially, and this comes on to some of the arguments that we ran later, it is not a wig, but it's sort of like a wig 2.0. So the point of the Kinsey system is that rather than having to have a wig that goes on your head and has to come off and sort of, be sort of glued in places and existing hair shaved, which can be very upsetting to some of the clients, what it did was it took the hair through this sort of mesh, which was placed over the scalp, and then the existing hands were pulled through using a crochet needle. And in total, this took several hours. It was a very skilled process.
And I
And
can
then it
only
was
imagine how
anchored. Sorry, Harriet.
painful. I can only imagine how painful it would be having hair pulled through with a crochet hook. It just sounds horrendous.
Yeah, so a very involved process, took a lot of time, really quite expensive, and as Harriet says, quite painful. But the point of this is that many women suffering with these conditions feel very upset about the idea of losing the remaining hair that they have. And for a normal wig, what you need to do is take off all of the hair and then put it on. So it's to do with the sort of the femininity of this particular solution is partly that you keep the hair that you have, and partly then that because it's anchored through, you get to keep this hairpiece on when you're in the shower. If you put a hat on, you're not going to be panicking about it coming off in the wind. And you can brush it normally like normal hair, etc. So it's partly more of also a psychological replacement for these women. What happened then, they would add any additional fibre to sort of fill out the piece. And then the finished result was cut and styled just as a normal hair. And there would be regular ongoing maintenance, including maintenance on a 6-weekly basis after fitting. Now, the reason for that was obviously that the hair grows. So normally women are not entirely bald. This sort of hair loss is patchy. And so the hair would sort of push away the mesh every 6 weeks or so. So it had to be refitted. And that will sort of link into what was ultimately the successful argument that we ran in the FTT unsuccessfully, and then Harriet and I ran in the upper tier successfully. But we'll come to that in a second. So the evidence that we had at the FTT, so firstly, obviously we had Mr. Glenn Kinsey for Mark Glenn. He was one of the founders of this company and who the system is named after, so the Kinsey system. He was an excellent witness. He answered honestly. He took time to think about his answers. If he didn't know the answer, very crucially, and this is something that I know Harriet and I both say to clients, if you don't know the answer, please don't make it up. Please
Just
don't
say
make
you
it up.
don't know, or I can't
Just say you
recall.
don't know. Luckily, Mr. Glenn Kinsey very much did that, and that was excellent. So that was very helpful. We also then had the officer from HMRC. As I recall, I only had a very short couple of questions. Just a client management point here. I think because of TV, clients often expect that when you cross-examine someone on the other side, particularly in issues that are very emotive, they expect that you're really going to go to town on them, a bit like in a US drama. And I think my client was a little bit disappointed that actually all I was really asking was, can you confirm that you were the person who was, dealing with this issue, and can you confirm that you had cited these documents? Thank you very much. Goodbye. So perhaps sort of a client management point there.
And Rebecca, the other thing I would say is, I don't know if you found this, but I certainly find it when you are cross-examining revenue officers, it is a very bad idea to get at all aggressive or pushy with them, because you will get the full force of the tribunal brought down upon you.
Absolutely. Yeah. Absolutely. There is an absolute presumption, whether or not this holds true, I simply will not be drawn on comment. However, there's an absolute presumption that HMRC officers do not lie, and that they are telling the truth. So putting things in an aggressive manner to HMRC officer is almost never good, unless it is beyond clear that they are making something up. And even then, tread
Rebecca,
lightly.
I was going to say, I've had a case where we had the documentary evidence to back that up, and it still didn't go well. So I would say always just be softly. You want to look for, I might be a mistake and I've forgotten, not an outright, I'm not telling the truth type approach.
Yes.
Yeah.
Yes, exactly. But just to note that your lay client might be a little bit upset that there's not a sort of, taking them down sort of approach. But yeah, so that was our oral evidence. We then moved to our documentary evidence, and there was an interesting question raised quite early on when I took over this case as to whether we should have expert evidence. Now, we had doctors' referral letters and NHS invoices, and on balance, we considered that this was sufficient. In this case, because expert evidence, obviously, even though practically it can be very helpful, and I'll sort of look at the test for that in a second, it is, of course, quite expensive because you're not only paying for the report to be produced, you're paying for the person to then attend, you're also then paying to extend the length of the hearing. And so it's something that's got to be balanced, and that is expressly contemplated in the test for expert evidence. So I believe the most recent case is the Lloyd LLP and HMRC. And what it says is that expert evidence should be restricted to that which is reasonably required to resolve the proceedings, and it should not, and it should be admitted unless there are compelling reasons not to. Here, we took the view that because the doctor's letters were actually quite detailed, they went into some detail about the psychological issues around this hair loss and the impact on these women, and we had very clear NHS invoices of the NHS paying for this to be done on many of these women. We felt that was sufficient in these circumstances. So it was considered, and we decided not to in the end. The other things that we had were, so obviously it was that the company staff were not themselves medical practitioners, but we had Glenn Kinsey talking about how often they see this issue and the fact that in reality, it's very obvious if someone has thinning hair or if they have broad, bald patches on their head. So it's not strictly something that needs a medical diagnosis. And that was sort of how it was put. We did have more evidence of referrals being received from medical practitioners. The NHS did sometimes pay. And what we also had was several articles from women setting out the impact of the hair loss on them sort of personally, professionally, and how this system had changed their lives. Now, the other thing you might be thinking, well, why didn't we try to call any of these witnesses? The reason we didn't is quite simple. The impact of having this sort of hair loss on these women is often so profound that they simply did not want to admit in a public forum that they had received this system. So whilst they were happy for their names to be in articles talking about it, they were not happy to come and sit in public and show the extent of the hair loss, discuss the impact on them in public, and have that recorded forevermore. Sorry, Harriet, look, you're going to say something.
No, I was just thinking about the young woman in question who was the subject of one of, I think, the doctor's letters, who suffered great physical discomfort from wearing a wig,
Yes.
sores and all sorts of hideous things from the adhesive and the wig, and yet
Yeah.
would still, when she was told that the NHS would no longer fund the Kinsey system for her, she still intended to go back to wigs because the depression she felt at the idea of not being able, not but showing her hair loss was so profound.
Yes. Yes, absolutely. And that was common across many of the women. In fact, most of the women who were treated with this system. And I mean, not only was that evidence sort of intrinsically by the fact of that we had these testimonials, but also this is not a cheap thing to go through, and it's 6 weekly maintenance. This is not a sort of casual thing that you can do in 5 minutes. Not only does it take hours to do, not only do you have to come back every 6 weeks, but it's also a relatively painful process. And so, if this was not a serious issue, genuinely impacting your day to day, you simply would not go through it. And this was one of the points that we tried and ultimately did not get across in the FTT. But luckily, this was more successful in the upper tier, which I think Harriet is now going to start taking you through.
So yes, I think preliminary to talking about the arguments and the decision, the FTT decision in this case is worth skimming at the very least, because I think it is one of the worst decisions I have seen for a very long time, just in terms of approach, in that it gives very little background as to why it is almost In parts, it is very difficult to follow what reasoning there is, if any. And that is why the first argument that we put was the failure to give reasons. We then went on to talk about fiscal neutrality. And we then went on to the Schedule 4 Group 12 requirements. So that's Schedule 12 to the Value Added Tax Act 1994. And so the services of adapting goods to suit the disabled person's condition and the meaning of something being designed solely for the relief of a severe abnormality. Now, to pause there, the last one that I've mentioned there, we weren't able to argue that in the upper tribunal. HMRC argued that it wasn't covered by the grounds, and the upper tribunal took their accepted HMRC's arguments on that point. In some ways, I think that the upper tribunal might have been better placed had they allowed that argument, because they could then have found for the appellant on that argument, and I think that would have been perhaps less of an eye-catching decision. And then we appealed on the Edwards and Bairstow ground. Now, for anyone who doesn't know what the Edwards and Bairstow ground is, Edwards and Bairstow was a case in which the courts set out when a court of appellate jurisdiction can interfere with a finding of fact. Now, ordinarily, you cannot interfere with a finding of fact at an appellate level, because obviously the court of first instance has had the witnesses and the documents, and it's seen all that, so it's considered to be in a much better position to do so. So the only time that an appellate court will interfere with a finding of fact is if it is perverse or unreasonable, and in effect that's Wednesbury unreasonable, so i.e. so unreasonable that no reasonable court could have made that finding. So it is a significantly serious state of affairs for that to be found. Now, I've gone on too far. Oh, no, I haven't. No. So those were the arguments that we put. And I'm going to, when we talk about the decision, we're going to come on to a little bit more what our arguments were. But this is that HMRC responded to these. On the failure to give reasons, they said the FTT's conclusion on whether the condition amounted to a disability was evaluative and multifactorial judgment and should be treated with appellate deference. That was the main thrust of HMRC's argument on that point. Fiscal neutrality. HMRC said that the Kinsey system and a normal wig were not interchangeable from the perspective of the average consumer, and so weren't sufficiently similar for the purposes of fiscal neutrality. The appellant's own evidence showed that most consumers seeking concealment could not use the Kinsey system, i.e. the target market, in inverted commas, for the product was not the same. There were material differences in semi-permanent integration, fitting and ongoing maintenance, which of course is true. And consumers chose the Kinsey system precisely because it was different from a wig. So that was their fiscal neutrality response. Services of adapting goods to suit the disabled person's condition. This was an interesting position that they took. So this is where the argument on artificial dissection came in. And this is, again, for people who don't know this is the position where if you have a supply of goods and services, which really is sort of one supply, and the paradigm example is the supply of a restaurant meal, because you obviously have goods, i.e. the food, but you also have services, then you treat them as a single supply. And where that is the case, you treat them as a single supply of services. And HMRC then went on to say, well, this can't be a service of adapting goods to suit a condition, because there is no supply of goods, there is only a supply of services. Now, hopefully you will be able to see the error in that line of reasoning. but if not, the upper tribunal did, and we will go into it. And so that was the position on that. I'm not going to go into design solely for the relief of severe abnormality, but if we look at the Edwards and Bairstow's arguments, basically HMRC supported the first tier's conclusion, which was that significant female hair loss and baldness was not a disability on the evidence before it. And if we just go back to the previous slide, that comes into service of adapting goods to suit the disabled person's condition, because there is no disabled person. They said there was no evidence that the medical profession treats hair loss as a chronic illness, and that hair loss did not substantially limit everyday activities. And Rebecca, it's not specifically stated in the judgment, but I certainly got the impression from being in front of the upper tribunal and from what is said in the judgment that that is where they fundamentally disagreed with the first tier. It does substantially limit everyday activities.
Yes, absolutely. And I think in reality, I think if you look at the cost of the service, the time of actually doing it, the fact you've got to come back every 6 weeks, and the sheer impact on women who do have significant baldness day to day in their lives, I think that is actually the right conclusion.
I agree with you. And unfortunately, the upper tribunal agreed with us too. So, failure to give reasons. This is from paragraph 34 of the upper tribunal judgment. So the tribunal relied on two cases principally, Flannery and Halifax estate agencies and English and Emery, Reinbold and Strick Limited. Now, Rebecca, if you're able to see the notes on the slides, because for some reason I can't, could you just pick up the quote from Flannery for me, please?
I don't have the notes on the. Hang on, let me. No, I can't see them, I'm afraid.
Okay, not to worry. So essentially, Flannery established this principle, and this is all around what actually.
No, Harriet, I got it. Got it.
Oh,
I
brilliant.
can do it.
Thank you.
So
the quote is far better than me trying to summarize it.
So, the duty to give reasons was explained as a function of due process and therefore justice. Part of the rationale is that fairness requires that parties, especially the losing party, should be left in no doubt as to why they've won or lost. This is especially so since without reasons, the losing party will not know whether the court has misdirected itself and thus whether he may have an available appeal on the substance of the case. Where the dispute involves something in the nature of an intellectual exchange, with reasons and analysis advanced on either side, the judge must enter into the issues canvassed before him and explain why he prefers one case over the other.
Thank you. And so in English, there was a similar approach where they said, look, if we're going to have the appellate process work, we've got to be able to understand why the judge reached his decision. It then went on to qualify that by saying, this doesn't mean that every factor which weighed with the judge in his appraisal of the evidence has to be identified and explained, but the issues, the resolution of which were vital to the judge's conclusion, should be identified, and the manner in which he resolved them explained. It is not possible to provide a template for this process. It need not involve a lengthy judgment. It does require the judge to identify and record those matters which were critical to his decision. So just another practical point here. One of the things, if you read a lot of judgments, as Rebecca and I do, you will notice is that a relatively simple point before a court of first instance is now often producing a much lengthier judgment than very complex issues before the House of Lords 30 years ago. And I suspect that is because of a greater awareness among the judiciary of the need to give reasons. However, it doesn't always mean that reasons are given. You can if you look at a standard sort of first tier tribunal judgment, what they tend to do is there'll sort of be an introduction. They'll talk about what the evidence was, then they'll set out what the arguments of the appellant were, and then what the arguments of HMRC were, and then they'll set out their findings of fact, and then they'll set out I've missed out some, yes, and then they'll set out the relevant law. Then they'll set out what facts they've actually found. Then they will apply the law to those facts as found. And what you can find is that sometimes that is very repetitive in that the same thing is being said. So you can imagine if a judge accepts a piece of evidence, that piece of evidence is set out in the evidence, it's then found as a fact in the findings of fact, and it's then discussed. It's probably then discussed when they set out the arguments of the two parties, how they both dealt with that particular fact, and it will then be mentioned again in the actual analysis of part of the decision. And I think one of the things that we can take from Mark Glenn, which is of much wider application, is that actually taking that sort of approach doesn't necessarily protect a judge from a failure to give reasons ground of appeal. So that's my practical point, somewhat. So yes, sorry. So what the upper tribunal did was they were particularly unhappy with this part set out there at the first bullet point of the FTT judgment, which pretty much amounted to the whole of the judgment on this particular issue. They said, based upon the evidence on a balance of probabilities, we are not inclined to find that significant hair loss or baldness in women is an impairment. In any event, had we found that, we do not find that it has a long-term and substantial adverse effect. And the upper tribunal correctly, in my view, identified that that amounted to a conclusion, not reasons as such. And then the reason I've put this quote in full is because somebody said I was correct, and that rarely happens in court, so I wanted to include it. But in conclusion, they said, against that standard, we consider Miss Brown is correct to identify that the FTT's findings were simply conclusions, not reasons. They then set out the text. This formulation does not explain why the evidence summarised earlier did not satisfy either limb. There is no analysis of the medical letters, the NHS referral funding context, the Lucy Perkins case, or the CB letter, and its account of physical injuries from adhesive wigs and psychological distress. In short, the FTT stated its destination but did not show the route it took to get there. And again, if you look at that quote and if you look at what the UT considered, the fact that some of these things had been set out didn't help the FTT because they hadn't actually given a proper analysis. They just said they'd set out the evidence, they'd set out the arguments, and then they'd said, this is what we've decided. And that wasn't good enough for Flannery or English. So that was where we came to on failure to give reasons. They felt that the FTT did not confront the central point of contention between the parties, which was whether on the facts severe hair loss amounted to disability in and of itself. And they particularly honed in on the fact that there was no consideration of whether or not this had an impact on everyday activities, and more broadly, whether such an impact had to be a physical limitation or whether it could be the UT used the expression wider social context. Well, to put that in context, what we argued specifically was we said, look, if you go out in public, on the street, at your job, wherever you are, how often do you see a woman with significant or severe hair loss who is not in some way covering it up with a scarf or a wig or a hat, whatever? And the answer is incredibly, vanishingly rarely do you see that. And we say that is because it's so culturally important. Hair is so culturally important for women. And we say that is relevant. Sorry, go ahead, Rebecca.
Sorry, Harriet. Sorry. It was purely that, I mean, so I ran this case in the FTT, and obviously before that for sort of several years until we got to that point. And I made a mental note that if I ever saw a woman who was walking around bald, that I would mentally note that so that I could, if when eventually we got the right answer, I would be able to say, actually, that is right. And over the years that I was involved with this case, I think I saw in total 2 women walking around with no hair, which is significantly less than the amount of women who have no hair because obviously a significant amount of women use the Kinsey system. So anyway, continue, Harriet.
Yes, and so what the UT did, and which I think was absolutely the right way to approach it, they said, look, the first tier didn't engage with that issue. They didn't sort of try to take a piecemeal approach and pick it. They said, this is the issue. We don't know what they thought about that because they haven't shown us the journey there. They then went on to talk about HMRC's submission, which was that the causes of hair loss might arise from conditions amounting to a disability. And they just said that was irrelevant, which frankly I was pleased to hear because I didn't think it was relevant either. And so that I think is pretty much, oh no, I've got a little bit more on reasons. And they said, well, look, we can infer that the FTT had agreed with HMRC's submission that hair loss didn't stop the person carrying out everyday activities. There's no explanation as to why that submission was accepted and the appellant's submission was rejected. So again, they weren't focusing on the outcome, they were focusing on the process, which of course is what giving reasons is. So they then went on to say at 52, the omission of explanation on this key point of contention was all the more conspicuous given the FTT itself acknowledged Mr. Kinsey's evidence that hair loss affects women's lives in so many different ways that it impacted every area of their lives. It might be expected that the FTT would test whether those many different ways spoke to day-to-day activities. For example, social interaction, professional conduct, public mobility, personal care. But the decision does not expose what the FTT analysis in that respect was. And I think that is absolutely right. Just to touch on one final point on this. Finally, HMRC submit that having mentioned the list of impairments referred to in the Campbell case, the FTT was entitled to conclude that baldness was not of a similar character. It was suggested that the FTT must be taken to have been guided by the reasoning in these employment tribunal decisions. While we cannot rule out that that is what the FTT thought, attributing such reason would amount to speculation on our part. The key point for the purpose of this ground is that we do not know what the FTT made of those decisions, as it did not say. So the Campbell decision, I think, Rebecca, you'll correct me if I'm wrong, that is a employment tribunal case on baldness.
Yes, and actually, I mean, so I had to dig pretty far to actually find anything at all on this issue. But yes, it was an employment case on baldness, so a slightly different context, and it was talking about how baldness was not a disability in men. But again, this was in a different context, and they were looking at it with a different set of facts. So there, I believe it was to do with comments made about baldness at work, as opposed to baldness as a general concept. And also, they referenced, and this is not me commenting, obviously I wasn't there, but they referenced in the judgment themselves that, as the panel knows, male baldness is very common. So I assume actually that the panel was itself bald. So was using some of his own experiences as well. In coming to that conclusion, but yes,
I have to say we were very much hoping for a female judge, weren't we, who we thought might have a better understanding of women's relationships with their hair.
We wanted a female judge. We didn't want a bald judge, ideally, just so it could be separated. In the first tier, I believe I had two men, and I believe they may or may not identify as having some issues with hair loss.
Okay, well, let's move on to a more neutral part of the case, fiscal neutrality. So, as I've mentioned already, the principle of fiscal neutrality is this idea that you cannot treat similar goods and supplies of services which are in competition with each other differently for VAT purposes. And this was addressed in the rank group case, which tells us that supplies are similar where they have similar characteristics and meet the same needs from the point of view of the consumers, the test being whether their use is comparable and whether the differences between them do not have a significant influence on the decision of the average consumer to use one such service or the other. So that's the principle. And this is what the tribunal said about it. They weren't very receptive to our fiscal neutrality arguments, which I thought was a shame. Uh, the essence of the decision was that because of the difference in terms of method of attachment, maintenance, and suitability, there were things that would be decisive for the typical consumer. And there was also this evidence that they were significantly different from wigs. So actually, the fiscal neutrality point, the fact that the Kinsey system was so much better, was one of the points that went against it in relation to fiscal neutrality.
I
So
mean, my personal view remains, and Harriet, you can tell me that you disagree. But my personal view remains that as it's a 2.0 wig, which is essentially how I put it, this is a 2.0 wig. If wigs are going to be zero rated, how on earth can you say that this better version, this version that doesn't scar people, this version that stays on your head, this version that gives women part of their identities back, how can you possibly say that that is not the same as a wig for the context of fiscal neutrality, not looking at the component parts? I still think there's something there, but anyway, that is just me.
No, I agree with you on that. I think the more difficult point on fiscal neutrality was always the fact that it effectively has two different markets, and the Kinsey system market might fall into the wig market, but significant sectors of the wig market don't fall into the Kinsey system market.
Absolutely, yeah.
So I
absolutely.
think that's the better
Yeah.
point on fiscal neutrality. Well, that's the better point against fiscal neutrality.
Yes.
But
Yeah.
in any event, we lost on that point.
We did lose on that point. As you can tell, I'm fine about it. Anyway.
So that brings us to services of adapting goods to suit the disabled person's condition. Now, this is one limb of group of the relevant group for zero rating, and it is worth going into a little bit of detail here. So what the upper tribunal said was the FTT did not find that hair loss in itself was a disability, but considered that in any case to view the Kinsey system as a service of adapting goods would dissect artificially what the system was. It went on to conclude in that paragraph that the supply of the Kinsey system was a single supply of services and that it did not therefore fall within item 3. HMRC emphasised this linkage in the reasoning to there being a single supply of services and submit that it shows the FTT had taken account of its earlier unchallenged finding that there was a single supply of services. They argue the FTT was correct to consider that the finding on a single supply of services prevented the Kinsey system from being a service of adapting goods under item 3. So this is, I think, where there is a real logical and sort of legal error in the FTT's decision, which the upper tribunal picked up readily. Now, just before we do that, it is useful, I think, to refresh our minds on the artificial dissection principle from Dr. Benyon and from Card Protection Plan. So what the UT said about this was that that case, being Dr. Benyon, considered the familiar question of single and multiple supplies and the approach set out in card protection in the context of patient visits to doctors who, in addition to prescribing, could both dispense and administer pharmaceutical services to patients, in contrast to the normal division between doctors and pharmacists, because the patients did not have a pharmacy nearby. The doctors argued that when administering drugs to patients, e.g. injecting a vaccine, that was a supply of medical care and a separate supply of goods. You've got to say that was a brave argument to put. Customs argued that the supply of drugs was ancillary to the single exempt supply of medical services. The House of Lords allowed Customs appeal, which had divided the transaction into various different stages, such as consultation, diagnosis, drug dispensing, and administration. The Court of Appeal's approach was considered by the House of Lords to involve just the kind of artificial dissection of the transaction which the European Court had warned against in CPP. And so you can see there, as you can with the restaurant example, you can see that there is something to be said for this sort of approach to it not being to the artificial dissection principle, but that then does give us a difficulty, which is we have to be able to identify where this line of artificial actually falls. Sometimes there will simply be separate supplies and they might be closely related. Sometimes to treat them as separate supplies will involve artificial dissection. And the upper tribunal said, while the first tier tribunal considered the appellant's case was trying to do the same here, splitting a composite supply of service into a component that involved the adaptation of goods, when it had already been determined by the FTT in agreement with the parties that this was a supply of services rather than goods, we consider that criticism was misdirected. The appellant was not seeking to split the overall service so as to constitute separate supplies of goods and supplies of adaptation of services in relation to such goods, but simply arguing that the essential features of the composite service, the provision of hair loss treatment, corresponded to the description set out in Item 3, Group 8, Schedule 12. The fact there was a single service did not preclude that service being viewed as one of adaptation of goods. That was not artificial dissection, but merely looking at the service to see whether it fulfilled the relevant description. And so that is the important thing here. What the upper tribunal was saying here is that, okay, we have said that there is there is an amalgamation into a single service of the supply of goods and the supply of into a single supply of the supply of goods and the supply of services. However, that doesn't mean that that single composite supply cannot meet the relevant description in Schedule 12. Now, that I think is incredibly important because, of course, just because we're treating it as a supply of a service, that is almost that's almost a legal fiction, or if not a legal fiction, it is a legal distinction. It doesn't change the fact that, as a matter of fact, a good was supplied, and therefore there was a possibility of goods being adapted. So they went on to conclude that the first tier tribunal fell into error because it had found the overall supply was one of services, so that Item 3 could not therefore apply. And this again, I think, is an interesting point of more general application, because what the upper tribunal is in essence saying is they're saying, look, we have this legal fiction, and when one has a legal fiction, one carries it, one continues that legal fiction as far as logic and or the legislation itself dictates. And what I think the upper tribunal is really saying here is that, look, this is the water's edge, effectively. This is the line beyond which we don't carry this legal fiction, and rightly so. So, designed solely for the relief of severe abnormality. Got this right? Yeah, no, sorry. So this is the Edwards and Bairstow point, and I've mentioned the Edwards and Bairstow principle. And what the FTT said is that there at the second bullet point, we said, well, we have under the above ground, and that's the previous ground on adaptation of goods, concluded the FTT's reasoning was inadequate. We cannot say that its conclusion that severe baldness in women was not of itself a disability was a conclusion that was one that no reasonable tribunal could have reached, and therefore perverse. We therefore reject this ground of appeal. So again, Edwards and Bairstow didn't succeed. It is a very high bar on which to succeed. And given that we had succeeded on other points, such that the appellant's appeal was allowed, I think that really does show that I think it was very unlikely that the Edwards and Bairstow threshold was ever going to be considered as having been reached. And to be fair, I'm not sure that they were wrong to come to that conclusion either. Rebecca, I don't know what you think.
Yeah, look, I think it's always worth considering, and obviously there was an argument here, otherwise we wouldn't have got permission on it. That said, yeah, I think probably that was the right conclusion overall.
Yeah, I mean, yes, it wasn't unarguable by any means, but I think probably they were right. Now, just before we talk about what next for Mark Glenn, very briefly, one of the things that the upper tribunal did was they, in effect, remade the decision. And one of the really interesting things about that is that they specifically took judicial notice of the fact that women, you get the fact that women are not seen out and about with hair loss, and that this is a reflection of how seriously socially debilitating hair loss is for women. I quite often ask judges to take judicial notice of things. They are rarely willing to do so. I think my best one ever was I would try to get them to take judicial notice of a well-established principle of foreign law, because my client wouldn't pay for expert evidence on the point, and they were not keen on that approach. But one does one's best. So they did accept that this was an application of judicial. They did accept that they could take judicial notice of sort of the proportion of bald women seen in public as a whole. I think it's a really good clarification on the limitations of the principle of artificial dissection, but more broadly than that, it does give us a reminder on how we deal with deeming provisions and legal fictions. And there is a really useful summary in the judgment of the law on fiscal neutrality. Now, in terms of whether or not there's going to be any more from Mark Glenn, we don't know. I suspect it's now becoming improbable that there will be, but it's not impossible. In terms of the interest that there has been, oh, sorry, well, don't need to share anymore anyway. Let me stop screen sharing. In terms of the interest that there has been in the case, and I think, Rebecca, you've had an inquiry on it.
Yes, I have, yeah.
And it's been mentioned in the press. Rebecca even found a really quite terrifying subreddit about how it was a desperately unfair decision because if bald females are disabled, bald men should be disabled too, and people were going to be getting benefits and all the rest because of it. As you can see, it doesn't do any of those things. It is a much narrower question. It is a much narrower, and it decides a much narrower point. What it says, in essence, is that in the context of the use of the expression disability in the Value Added Tax Act, female hair loss meets the threshold, so that if you are adapting goods to meet the needs of women who are disabled by their baldness within the relevant VAT context, then that will be a zero rated product. That is it. It isn't an exciting equalities case. It isn't a human rights case. It is much narrower than that. But there are still some useful points in there of more general application for VAT and indeed for statutory interpretation. Rebecca, have you got anything to add, or shall we see if there are some questions?
I agree with what you have said. I think it's I think the discussion on fiscal neutrality is useful. I think it's a useful look at how these provisions apply to quite a sort of novel set of facts. But given we have 8 minutes left, does anyone have any questions?
Either just unmute yourself or put it in the chat, either way. Hello, yes.
Harriet, yes, hi. I'm interested in the very last point, actually, that you just touched upon, on whether this is compliant with the Equalities Act or not, if we are going to be exempting the product for women, but not for men.
Well, that's an interesting point, and I'm actually, unless she really doesn't want to, I'm going to let Rebecca take that point.
Yeah,
Do you have any views, Rebecca?
Yeah, I'm very, very happy to take that. So, firstly, the point in relation to this product is that it only applies to women, because it's the type of product which applies to patchy bald loss all over the head rather than male pattern baldness. And so it can only apply to women, which is why it was being run that women had a disability here. It has not been used on men. And so that's why it was being run. I don't think there is an equalities point on that basis, because it's not that men could be in the category and therefore are not being included in the category. They actually can't be in this category. So I don't think it can be applied more broadly.
So we're saying the product was designed with women in mind, and it's
Precisely.
only for women. Okay.
Precisely. Yeah.
Yep.
Yeah. So
it would be
I don't think actually
a bit like
yeah.
getting upset about the VAT status of tampons.
Yeah.
Yeah.
For example. Yeah.
Yes.
Which I know a lot of people did, but yes.
No.
Actually, people do get very upset about that, but not for that reason.
Yeah.
But yes.
No. Understood.
Yes.
Thank you. I've got two very other quick questions while I've got the
Of course, yes.
the seat of the main.
You have the conch, as it were.
Thanks. Now, forgive me for having not fully digested all the case. So, am I right that both sides agreed that this wasn't a wig? And I'm interested in why that was the decision of both sides. And also, I'm also interested in item 3 and whether that reads across to item 2, because item 3 doesn't specifically link to medically designed appliances, if I'm right.
Okay,
and whether they saw a link there.
So in relation to the first point, and again, I'm going to ask Rebecca to correct me if I'm wrong. I don't think it was agreed that it wasn't a wig. I think that a lot of the marketing materials, it was marketed on the basis that it was significantly better than a wig.
Precisely,
And so
precisely that point. So it wasn't that we went in and said, we agree this isn't a wig. I ran the argument much more widely than that. I ran the argument that this is a wig 2.0, so effectively covering both sides. So either we can say it is a wig, therefore fiscal neutrality, or it's a 2.0, and therefore we're adapting goods to suit services. And that's how I ran it. And it was waiting to see how the judge sort of fell in terms of the evidence. Yes.
Thanks.
Okay, and sorry, just repeat your second question was on item
3.
Item 2 and 3.
Whether there was a read across to item 2 on the status of the goods, because item 3 is a bit more non-specific.
So item 2 is the supply to a disabled person for domestic or his personal use, or to a charity for making available to disabled persons, etc., etc. And our relevant one was, what was it? Was it G? Equipment and appliances not included in A to F above, designed solely for use by a disabled person. So that was discussed at length, and whether or not this was in fact equipment and appliances designed solely for use by a disabled person. And I think that's where the point that actually you couldn't use it for thinning hair. The thinning hair system was something else. It was only for people suffering this very severe hair loss came in. And then if we go down to group 3, the supply to a disabled person of services of adapting goods to suit his condition. So really, it only feeds into 2 in the sense that there's probably more context of what constitutes disabled person in the context of item 2, not item 3. So the supply to a disabled person of services of adapting goods to suit his condition could be a supply of goods which are goods which are themselves within item 2, but it doesn't have to be for goods within item 2. So it could be, I don't know, what would be something? It could be adapting a car to be driven by somebody who has limited physical mobility or something like that. That could be within group 3, that could be in item 3, even though the car itself is not within item 2. Does that answer the question or not really?
It does, yeah.
Lovely. Okay, thank you. We have another hand up. That is it? It's an AM. Yeah, Adam.
No, we have 3 minutes, I think, before the window will automatically close, I think. So let's be quick.
Okay, Adam.
It just links on to the end of what Scott was saying. The question, so specifically around disability, again, forgive me for not, about the background of the case and so on. But was there a discussion around, at what point the person becomes disabled? Was that taken as a position? Because I know we tend to think of, the Equalities Act, disabled, it's XYZ. In this case, was there a line drawn? Was there discussion around that as to, okay, well, they're not quite disabled yet, which sounds a really odd stance to take. But was there any discussion on that?
So it was, but only in the sense that it didn't really arise. So in order to have the Kinsey system, the hair loss had to be serious and significant. It had to be really quite bad in order for it to work, because there had to be somewhere for the mesh to sit, and there had to be then hair put through. So a minor patch wouldn't work. And so it didn't really arise because of that. And that was one of the points we tried to make clear in the FTT. And again, sort of emphasising the upper tier.
Gotcha. That's great. No, it's really helpful. It's a given, effectively, if they're using the system. That's great. That was all. Thanks.
Yeah, on that case, yes. And I think we've got one more hand up. Richard.
Yeah. Thank you both for the presentation, really helpful. These two questions are linked, I think, and it's really around HMRC's reaction to the loss and applied to the limited facts and the narrow sort of interpretation on those facts. Are they likely either to change the law or to litigate further?
I don't think they're likely to change the law, and it's becoming increasingly unlikely that they're going to push it up to the Court of Appeal. So probably neither. Though why they took it to the upper tribunal, well, we took it to the upper tribunal, didn't we? That's why.
That's why they came, Harriet. We went. But yes, yeah. So increasingly unlikely. I think the time limit is running out, but also they don't need to copy us to an application. So it's possible an application's been made, but I think it's increasingly unlikely.
Yeah.
Given we haven't been notified.
Yeah.
So
yes. So probably nothing. And they may come to regret that, because there are some, if you read the decision, there are some quite broad points in there that I, for one, would certainly be loving to use in future cases. So they may.
Absolutely.
There's some good general dicta in there that have a much wider application, as I've tried to highlight. Now, I think we're about to run out of meeting time. So if you have any other questions, our email addresses are on our website. Just drop us a line. We love talking about tax. Thank you so much for listening. I hope this has been helpful.
Thank you, everyone.
Bye.
Bye.
Hey. You all right? Cool. Yeah, I'm all right, thank you. I'm all right. Where are you today? Odd. And you? Oh, is it? Right. Okay. But what? All right. Okay. Say no more. But Justine's not around, and the other guys. Right. Cool. Okay. Well, thanks for making the effort, and thanks for going in. So that's all good. I would, if I was you, net of yesterday's call, I would just keep a record, and it's not for me, because you know that I'm not like that, but it's more for HR and the presenteists amongst us who like to browbeat everybody else about